I am Beverly Hank, and I am very pleased to introduce our guests for this evening. Mélanie Benard is a disability rights lawyer and activist based in Montreal. She is an executive board member of the Council of Canadians with Disabilities. After completing her law degree at McGill University, she articled at the health law firm Menard Martin Avocat. In 2015, she co-founded Quebec Accessible, a grassroots initiative advocating for a stronger provincial accessibility law for people with disabilities. Mélanie has presented her comparative disability law research at numerous conferences and in the media. I would like to remind you to turn off your cell phones so that we're not interrupted. And if you'll hold questions until the end, Mélanie has agreed to answer your questions in both English and French. Thank you very much. Have a good presentation.
So hello, everyone. Thank you so much for the invitation. And a little disclaimer at the beginning. As she mentioned in my biography, I did my articling at Menard Martin. I'm not sure how many of you in the room are familiar with them. It's a health law firm that represents patients and users of the health and social services system. So I gather that most people in the room are probably friends, loved ones, caregivers of people struggling with mental health issues. And Menard Martin represents patients that are contesting being kept at the hospital against their will or contesting treatment orders. So I worked there for about a year, and I just wanted to put that out there right at the beginning. But today, I'm speaking as a lawyer presenting the state of the law as it is currently. I'm going to try and do that in as neutral and balanced a way possible. But I just wanted to put that out there so people are aware of that. And I fully recognize that these are not black and white issues. They're very complex emotional issues. And just to tell you that I can see things from different perspectives simultaneously. I actually lost a friend to suicide just a few months ago. She had been hospitalized for a few months, and she drowned herself in the river a few weeks after getting released from the hospital. So as I said, these are not black and white issues. The title of my presentation is Mental Health Law in Quebec, a Delicate Balance. As a lawyer and a law student, you really start to understand the symbol of the scales of justice, because there always are rights and interests at stake. And I would say in this area of the law in particular, it's really, really hard to strike the right balance. So I'm going to start out by presenting just some of the basic legal principles in health law and in human rights law. Some of you may be familiar with these already. And then I'll be delving into the issue of consent to medical treatment and talking about treatment orders. And then we'll talk about involuntary hospitalization, also known as civil commitment or confinement. And my presentation is going to be relatively short, I think, because I wanted to leave a lot of time for questions and answers at the end. I should say right off the bat that I can't answer questions about specific cases, or if you have questions about your own personal situations. Unfortunately, that's not what I'm here for tonight. But if you have some general questions about the law and about your rights, about the rights of patients, then I'd be happy to answer your questions. So I'm sure that all of us have heard about the Canadian Charter of Rights and Freedoms. I thought that seemed like a good place to start. There's a copy of it right here. I don't know if that's going to show up on the screen, but the Canadian Charter was adopted in 1982. And in Quebec, we also have our own Charter of Human Rights and Freedoms that was adopted in 1975. And these two laws are considered the supreme laws of the land. So all other laws and all forms of government action have to conform to the Charter. The two charters protect the right to liberty and security of the person. They use slightly different terminology, but they both protect those rights, as well as the right to dignity, and the right to equality. In this case, it's the right to equality for persons with disabilities. It was mentioned in my biography that I'm a disability rights lawyer. Well, this may be shocking. It's still shocking to me, but I'm actually the only disability rights lawyer in Quebec, as far as I know. And it's not easy. It's been mostly volunteer work for a very long time. And I might actually be having to leave Quebec imminently in order to find stable employment. So it's an area of the law that really isn't very developed here in Quebec. And disability issues that the right to equality is really, really important. So you sometimes hear of the term mental disability, mental health disability, but people with mental disabilities, and the Quebec Charter uses the term means to palliate a handicap. That would be things like a service dog. In the area of mental health, that might be relevant, because I know more and more people are using zoo therapy, and animals can often have a soothing or calming effect. So if that's a means to palliate a handicap, again, that's the terminology used in the Quebec Charter, then you are guaranteed the right to equality and freedom from discrimination. So you should be able to bring that animal with you. Just an example. The two charters also protect inviolability and the integrity of the person. So what does all this entail? Well, it's that when we talk about liberty, that includes personal autonomy, which means the right to make decisions about one's body, control over one's body, and the right to make treatment decisions. When I'm referring to treatment, it's any kind of medical care. And in Quebec, housing, like you can be, if you're going to be placed in a kind of long-term care facility or something like that, that falls under treatment under the law in Quebec. You may have heard about the doctrine of informed consent. We often talk about free and informed consent or enlightened consent. So adults, including adults with mental disabilities or mental health issues, have the right to consent to or to refuse medical treatment. So this is the broad statement, sort of the foundation based on the right to liberty in the Canadian and the Quebec charters. The Quebec Civil Code, I kind of refer to this as the Bible. It even sort of looks that way. It's just as heavy. It contains all the rules that are supposed to govern people's lives from birth until death. And at the very beginning of the Civil Code, there are articles governing medical treatment and the doctrine of informed consent. So according to the Civil Code, every person is inviolable and is entitled to integrity of his person, except in cases provided for by law. No one may interfere with his person without his free and enlightened consent. So the term free in this context means without coercion or undue influence or pressure. So you're making the decision of your own free will. And enlightened means that you're given all the information required to make an informed decision. So about the risks and the benefits of the treatment that is proposed. The Civil Code goes on to say that no person may be made to undergo care of any nature, whether for examination, specimen taking, removal of tissue, treatment, or any other act, except with his consent. Now, there are exceptions. I mentioned that is kind of the blanket statement. That's the starting point. But there are exceptions in emergency situations. If there's really a crisis and the person's physical safety is at risk, then people can be treated against their will without their consent. And also, something that will be relevant, I think, for us tonight, is that adults who have been assessed and found to be incapable of making treatment decisions can also be forced to accept medical treatment. And I'm going to unpack that a little bit because there's a bunch of concepts in there that are important to understand. So the law starts with the premise that all adults are presumed to be capable of making treatment decisions. So there are different rules for children, but if you are an adult, then you go into a hospital, you're assumed to be capable of making a free and informed decision about treatment. And if there are doubts about your capacity, if the doctor is maybe thinking, I'm not sure, there's something else going on here, let me just make sure that this person is fully understanding the information I'm giving them. There's a 5-step test that they need to take to assess the person's capacity. So the first question to ask is whether the person understands the condition for which the treatment is proposed. We also ask whether they understand the nature and the purpose of the treatment, and whether they understand the risks involved in undergoing the treatment. So there are very few forms of treatment that don't have some kind of risk or side effect associated with them. So the person must be given the information about those risks in order to be able to make an informed decision. So we need to make sure that they understand what those risks are. And they also need to understand the risks involved in not accepting treatment. So I guess you could say it's kind of a cost-benefit analysis, looking at what the potential advantages are of the treatment, what the potential disadvantages are, and what the consequences could be of refusing the treatment. And finally, the criteria that I always find gets a little bit tricky to apply, we look at whether the person's ability to consent is affected by their mental health condition. So it could be rather subjective, I think. It's assessed on a case-by-case basis, but all of these questions should be looked at when assessing whether an individual is capable of making a treatment decision. But I'm just going to repeat again that we are presumed to be capable. So unless there is some reason, some indication that the person might be incapable, then we're just assumed that we can make our own decisions. And it's also important to mention that even if one is under protective supervision, so I don't know if everyone's familiar with tutorship, curatorship. We often see this in the context of maybe people with dementia. So people who have an appointed legal guardian. We still don't just assume that they're incapable of making treatment decisions. This may seem surprising, but I mentioned like the supremacy of the charter. That's really the starting point, is that people have the liberty to make their own decisions. So capacity is really assessed on a case-by-case basis, and it can fluctuate over time. These things aren't fixed. They evolve, as we all know. I think mental health fluctuates. And there are more difficult periods that are a bit better. So the capacity must be assessed on an ongoing basis. And a capacity that I am referring to here tonight is the capacity to make treatment decisions. So I had talked about protective supervision, like curatorship, and people who have a tutor that's making, for example, financial decisions for them. So that's a separate assessment. When you're looking at the capacity to make financial decisions, you wouldn't be necessarily asking the exact same questions. So here, the criteria that I've given you is specifically for the capacity to make decisions regarding medical treatment. So once we've assessed the person's capacity, if we find that they're capable, so if they meet all the criteria I just went through, then they have the right to refuse treatment, and that refusal must be respected. And I know that, this can be difficult to wrap your head around or your heart around when you're wanting to be protecting the individual. Like I said, it's not black and white, but the law has to slice these issues somewhere, right? So if it's following the strict letter of the law, if the person is capable of refusing consent because they understand the risks and the benefits of accepting or refusing the treatment, and they insist on refusing the treatment, then their refusal must be respected. I said this is it's difficult to sit with, it's difficult to accept a lot of the time, but it's important to distinguish between a person's legal interests, and in this case, it would be the right to liberty, autonomy, self-determination, versus medical interests. And that's something we often refer to as the best interests of the person. And I could give a whole other presentation about the evolution of this in this area of the law in the past, 60, 70 years. But we've really seen, you're probably aware of this, a pendulum swing. So we went from, I would say, prior to the 1960s, a really paternalistic model of the doctor knows best and can impose whatever form of treatment they think is in the person's best interests. And with the civil rights movement and the adoption of the Charters of Rights and Freedoms, we see that personal autonomy took on a lot greater importance. And I would say, it's hard to determine exactly where the pendulum is right now. We're being recorded, so I want to be slightly careful, but I can tell you that being involved in a lot of these cases, the criteria are difficult to apply, and they're not always applied in the exact same way, so it can be difficult to predict the outcome. But it has to be clear that sometimes the person's best interests may not coincide with their legal interests. There's unfortunately, those things can come into conflict. I'm not sure if anyone has heard of the Starson case. It was a case from the Supreme Court of Canada in 2003. And that case reaffirmed all the principles that I'm mentioning here, and it affirmed that capable adults have the right to make bad decisions. So it can be very difficult to watch, it can be very difficult to accept, but following the strict letter of the law, like I said, if those criteria have been met, and the person is found to be capable, then they have the right to refuse treatment, even if that can have negative consequences. An issue that's come up a lot lately is the right to physician-assisted suicide. So we see that if people are capable, are competent, those words are often used interchangeably, then you have the right to refuse even life-saving treatment. And not only that, we've taken it a step further that you can actually precipitate your death. So, but again, this is all hinging on the fact that you are capable of making treatment decisions. Right now, the law that was adopted in Quebec on physician-assisted suicide, and then the changes made to the criminal code by the federal government, have restricted it to people who are capable of making treatment decisions. There's been a push to broaden that so that people can make what they sometimes refer to as the living will, or have some kind of decision made in writing, so that if they become incapable, then they would have access to physician-assisted suicide. But currently, it's reserved for people who are capable of making treatment decisions. And I just bring that in because the issues are often the same, and it just gives a good example of the fact that if you're capable, you can make a decision that other people might find unreasonable or wrong, and it can go as far as ending your own life. So the stakes in these situations are very high. However, if we do the capacity assessment and find that the person is incapable of making a treatment decision, so if the criteria are not met, they don't seem to understand the risks and the benefits of accepting or refusing treatment, and they continue to refuse the treatment, then the hospital can seek a court order to force the treatment on the individual. I'm not going to go into too many details about this, but I'm sure people might have questions afterwards. For now, I'll just say that these treatment orders are issued by a judge, so it goes to the Superior Court. And generally, from what I've seen, the treatment orders usually last for about 3 years at a time. You can see them for shorter than that. You can see them for up to 5 years. And once this treatment order has been issued, then the person doesn't have a choice anymore. They must go and accept the treatment. And if they do not do that, then the police can intervene. It's written usually in the court order that if the person doesn't show up for their injections, if it's for an injection, then the police can be sent to their home and can bring them to the hospital to make sure that they are taking the treatment. So I think I'm actually just going to leave it at that for now for the treatment decisions. Was there a question in the back? No? Oh, okay, sorry. So I'm going to go to civil commitment now. I know it's a lot of information, and these are really just the broad strokes, but I think we can maybe unpack some of the details during the question period. So civil commitment, I said, is also referred to as involuntary hospitalization or detention or confinement. So this is when you're kept at the hospital against your will. And these things are often separate. I mean, they can coincide. So someone can be kept at the hospital against their will and forced to accept treatment because they're under a treatment order. But they can also be under a treatment order while living in the community, and they can be hospitalized against their will without being under a treatment order, so they can still have the right to refuse treatment while in the hospital. So there are lots of different ways that this can play out on the ground. You might be familiar with the law P38. I've got a copy of it here, and you can take a look at it afterwards if you'd like. This is all available online. And I should mention that I'll make my PowerPoints available as well if people want to take a look at them afterwards. So the law P38 is an act respecting the protection of persons whose mental state presents a danger to themselves or to others. And the criteria in this law is danger, or sometimes referred to as dangerousness or dangerosity, because legal practitioners like using really complicated words for seemingly no reason sometimes. But so the criteria is, does the person pose a danger to themselves or to others? The danger has to be significant. It has to be probable or clearly foreseeable in the present or the near future. So again, there has to be an assessment. In this case, it has to be by two different psychiatrists. And some of the rules governing this process are in this P38 law. Some of them are also in the Civil Code of Quebec. So you kind of have to piece things together a little bit to figure out all the rules that apply. If the danger is grave and immediate, again, you might have noticed that they can be subjective terms, so people are going to give these words different meanings depending on the context. But if the danger is grave and immediate, then the person can be kept for up to 72 hours at the hospital without going before a judge. But this is really in fairly circumscribed situations if the danger is really acute. Again, if the danger is grave and immediate and the person is still living in the community, then the police can intervene at the request of a crisis intervention unit. So in my experience, I've encountered the Urgence Psychosociale Santé, I think they're called, the UPS Justice, and I think they are, there may be other units as well, but they're the only ones that I'm familiar with, and it's people who are trained in crisis intervention. So I think social workers, maybe psychologists, I'm not sure. So if a member of the crisis intervention unit feels that the danger is grave and immediate, they can contact the police and have the police bring the person directly to the hospital. It's also possible if the crisis intervention unit isn't available, then the legal representative of an individual in crisis, so that can be their mandatory, their tutor, their curator. I won't go into the details of what the differences are between those things, but suffice it to say that the person has been deemed to be incapable in some way of doing certain things, and so they have a legal representative. Well, that legal representative can request that the police intervene. It can also be the spouse or a close relative of the person in crisis. But this is only if the crisis intervention unit isn't available. So, I hadn't really thought through how that would play out because I'm not usually involved at that stage of the process. My assumption is you would probably call 911, explain the situation. They would direct the call to the crisis intervention unit that are supposed to respond really fairly quickly. The crisis intervention unit will make the assessment, and the police will or will not get involved depending on what the conclusions of that assessment. If the crisis intervention unit isn't available and there really is an emergency situation, then the police can come and bring the person to the hospital, but the police officers themselves have to assess the situation and decide whether they think that these criteria have been met. Well, and I wanted to specify, I have a picture of The Simpsons here. I'm not even a Simpsons fan, but I just thought these are such heavy subjects that if we can have a little bit of levity here. This is the judge from The Simpsons. If the person is brought to the hospital, undergoes these 2 psychiatric assessments, and both evaluations come to the conclusion that the person represents a danger to themselves or to others, then the person will be informed that they're going to be kept under a court-ordered confinement. So the person may at that point accept to stay at the hospital voluntarily, but if they refuse, if they contest, then they can go before a judge, and this is through the Cour du Québec. So I've never quite understood why they have it go through separate courts, but for the treatment orders, it's the Superior Court, and for confinement orders, it's the Cour du Québec. And this is the kind of case that I was most frequently involved in. And so the person that contests has the right to an attorney. Again, it's their charter-protected rights because their liberty is at stake. I can tell you that most of the cases I was involved with, it's through legal aid because people are often in precarious situations and situations of vulnerability. And so we go before a judge, and the judge assesses whether, by looking at the evaluations by the 2 psychiatrists, and by listening to the person testify in court, the judge decides whether the person represents a danger to themselves or to others. And if they come to the conclusion that there is a danger, then they can order confinement. There's no maximum duration in Quebec. Unlike other jurisdictions, I spent some time this summer comparing all the mental health laws in the different provinces and territories in Canada, because each jurisdiction has its own law. And they're often fairly similar, but in other jurisdictions, there's a set limit as to how long this confinement can last. And it doesn't mean that you can't be kept past that duration, but it means that the whole process starts again when that maximum duration is reached. So no maximum duration in Quebec, but the length that I most often saw was around 30 days, sometimes 21 days. I've seen as little as 5 or 10 days. So it really depends. There's some discretion there left to the judge. And also we'll look at what the psychiatrist has requested. So if the person is ordered to stay at the hospital against their will, they still need to be assessed on a periodic basis. The law says that they must be assessed at the very minimum after 21 days of being kept at the hospital under a court order, and every 3 months thereafter. And if based on these assessments, the physicians determine that the person no longer represents a danger, then that person must be released immediately. I mean, I understand there's a lot of paperwork and bureaucracy to get through, but they can only be kept at the hospital against their will as long as that criteria is met and they represent a danger. And I'm not sure if anyone's seen this process in action, but the people who are hospitalized against their will do have the right to appeal the court judgment to the Tribunal Administratif du Québec, the TAC, Administrative Tribunal of Quebec. So there's a whole process in place. They can send a letter to the Tribunal and ask for the decision to be reviewed. In principle, the tribunal is supposed to hold a hearing. So it's a panel, usually of a psychiatrist, a lawyer, and often a social worker or a psychologist that will actually go to the hospital and hear the patient and listen to the evidence and decide whether they're going to uphold the court decision to keep the person hospitalized against their will. In practice, unfortunately, I don't know, budgetary constraints, austerity measures, I'm not sure. The clients that I was working with would often contest to the Tribunal Administratif du Québec, but the delays for the hearings were so long, there was such a backlog that I never actually had the chance to take part in one of the hearings because the court order would have expired by the time the Tribunal had a space to go, had time to go and and hear the evidence and make a decision. So there are some real administrative issues here. I'll leave it at that. But the letter of the law is that you have the right to appeal the decision. So I'm actually going to end it there. There's a lot of more information I could share, but I'm going to see, I guess, what people are interested in hearing more about. One thing before I forget, I'm currently, in my biography, they mentioned that I'm on the board of directors of the Council of Canadians with Disabilities, and we are currently involved in litigation in British Columbia that is challenging the constitutionality of the BC Mental Health Act. I mentioned that all the laws across the country are slightly different, and British Columbia is the only jurisdiction in Canada that has what they call a deemed consent model. So I mentioned how adults are presumed to be capable of consenting, that we need to assess their capacity, and only if they're found to be incapable based on that assessment can treatment be imposed on them against their will. BC does just the opposite, actually. It presumes that all patients that are detained at the hospital against their will are incapable of making treatment decisions, and the physician can impose any kind of treatment, and there's no appeal mechanism. And there's also, I didn't really get into it too much, but the whole, there's a whole regime in place in every jurisdiction in Canada for substitute decision makers. So I had mentioned tutors, curators, spouses, close relatives. So you can be either appointed by the court in a more formal capacity as a tutor or a curator, or in a specific instance, you can be recognized as the person who has the authority to make a decision on the behalf of the person who's been found to be incapable. In BC, the person detained at the hospital against their will doesn't have access to a substitute decision maker. So all other kinds of patients would have access to that, but if you're a psychiatric patient that's detained against your will, you lose that right. So I'm not the attorney in the case, but I'm the representative of the Council of Canadians with Disabilities, which is one of the plaintiffs in the case. And that lawsuit was just filed about a week ago. It's going to take a long time to see how it's going to play out. But we're just trying to ensure that these basic protections are in place. I made the disclaimer at the beginning. I understand I've been indoctrinated a bit to take the perspective of the patients, but these are not simple issues, and it's not that, even in this lawsuit, we're not at all arguing that treatment can never or should never be imposed against someone's will. It's more that you need to adhere to the charter, and you need to have these safeguards in place. So in emergency situations, or if the person has been assessed and found to be incapable, then yes, you can impose treatment, but you need to at least assess their capacity and before you make any decisions in that regard. So again, I can talk more about that if people have questions. I do understand that people may not be happy to hear about these things, because when it's someone we care about and they're in a state of crisis, I understand. Like I said, I have personal experience with this, but I think it's important to understand what the law says, and then there's what we might want to see happen, and there's everything in between, which is what actually happens on the ground.